Okay, we're at Liverpool Crown Court today in Derby Square. I have Marc with me. I'll let Marc explain exactly why he's here. Could you just tell us why you're here, Marc, please?
Well, basically, in December, Liverpool Council got a liability order against me, and it was about the due process of law. And what actually happened when the court admitted, the magistrates admitted that the council had not submitted costs, and the legal advisor admitted that they had not submitted costs. When I asked for the costs in accordance with the law, and their admission that they'd not seen it, not had a copy of it, the law says no liability order can be made. There are a number of other breaches of what's called the due process of law, and fundamentally we are all entitled to the due process of law. And so this here now is what the whole knock-knock challenge is about, to establish where is my obligation, which nobody's answered so far. And we've been through a lot of barristers who've assisted. They use barristers to try and threaten people with costs. A lot of people have had costs awarded against them. This is the only tool they have, because if it existed that they can impose their will upon us, because I can't tell anybody what to do. Nobody can tell anybody what to do. And with this, if there was an authority to do it, all we're saying is show it to us. So today basically is a full council tax hearing in the district. There's no way that 650 people in Westminster can impose their will on any single person, let alone the whole population. So it's about individual rights, where everybody's rights are respected, was that it's a duty of the person making judgment to explain to you where your belief is wrong. I.e., we're all entitled to a reasoned judgment, and he undertook to give a reasoned judgment. He's had the paperwork for a while, so he possibly has a draft, an outline, and then depending on what he hears today from the two arguing children, myself and Liverpool Council's barrister, depending on those arguments, he may change it a bit, and then at a later date hand down the final judgment with the reasons. If he rules in my favour that there is no evidence that I have an obligation, that's the end of council tax nationally. Not only council tax, but it goes way beyond that. Anything that Parliament is trying to impose their will on individuals is totally shown to be lawless. And what's happening is we are finding contradictions over the hundreds of years, and most of the stuff is being resolved. So there's nothing new today from what was for instance, of the Bill of Rights, even earlier back to Magna Carta, even to the original Magna Carta 1215. So we're arguing about the same things, but today we have different tools. All the great jurists in the past literally had to go through papers, and then if you have read 1,000 judgments, and you say, hang on, I remember seeing something in those. They didn't have the tools to do what we can do today. So all that's happening is the contradictions are being highlighted, and those contradictions need to be resolved.
Okay, we're outside the courts. This is a follow-up to this morning's video. Marc, can you tell us how it went, please?
It was the due process of law, no complaints. Very, very good. The judge was listening to both sides' arguments. They did not send out the video link for people to watch by public. There were over 70 applications for a video link, and it appears that the judge actually stopped that video link being sent out, so that they'll be further investigated. But because we hadn't had the video link and I didn't have that information at the time, I asked for to make a verbal application to record it in court, because the court undertook, and that means my word is my bond, to provide it. They did not explain anything or make it conditional that, oh, it's up to the judge or it's up to anybody. So under the open principle of open justice, using the modern technology, there's absolutely no reason why every single court case in this country is not live streamed. I can understand his concerns because he denied me the right to record, got the his clerk to read out and make clear to everybody in the court that to record is a contempt of court. And then I asked him for a reasoned judgment, and he felt very uncomfortable with that and failed to provide a good reason to deny me recording. I undertook to the court that I will use it only for private purposes for an appeal should it be necessary, and even then he did not accept my undertaking and refused me the permission to record. The case itself, they opened with their witness, and the issues were she claimed that a demand notice was sent, yet her evidence showed a bill was sent. In regards to the summons, she did not know. Basically, she just said, "This is the costs," and that's a total breach of the Ewing judgment from the High Court. That alone wins the case for me. I don't need anything else, just that admission wins the case. However, we argued other points of law as well, but the judge essentially intervened with me questioning the witness on points of law. Now, this comes back to the authority to breach another person's peace. You require the evidence of lawful authority to breach somebody's peace. That means whoever sent that piece of paper, they must know the law. And the judge intervened and said, she's not a lawyer. Well, guess what? Ignorance of the law is no excuse. So, but with the barrister from the council, he presented their side of the law in rebuttal to what I'd said. And basically, we've come across so many barristers now who are trying to defend this, and the council's argument was a simple one. In accordance with Section 16 of the Local Government Finance Act, the court has no jurisdiction to question whether council tax is lawful or not. And that is not correct, because it actually says that's one of my options. If I choose not to use it, doesn't mean I can't use other options, including fundamentally the judicial oath is to the rule of law, or to the law, and the case of Proclamation 1610 defines and resolves the law of England is from three sources: customs, common law, and statute law. So what they were doing is basically just trying to rely on statute law, ignoring the common law duties of the judge. But it was very fair, and it went from my submissions on law to the council having the opportunity to rebut those submissions on law, which really were totally unsubstantiated. A lot of them were just merely the barrister's opinion, just because he's a barrister. Oh, that makes it true. It doesn't work like that. So at one point I actually pointed out, in regards to the opinion of the barrister, opinions are to a penny. The council has failed to provide legislative authority or common law authority higher than what the court I've presented. And therefore, from the evidence before the court, unless the court has a higher authority and we have the opportunity to rebut it, that there's the default judgment. So there were 6 points of law. The constitutional arguments we didn't expand on in much depth. However, he did confirm he had my original submissions, all the submissions from the void order, and these submissions, and he's going to give what's called a reserve judgment within 28 days. So we've got a written judgment. That alone is a major victory, because once things are committed into writing, then you can rationally deal with it, as opposed to a magistrate saying, or as this district judge said in the beginning, he could not provide a reasoned judgment, a rational reason, to deny me the right to record. So we're getting this in writing now, and that will include the recording issue. so that we can move this into the higher court, certainly with recording, because once people start to see, this case was the way I expect the case to run, the way the judge should be dealing with the people, as opposed to what's happening in the vast majority of the magistrates' courts. And this would have been an excellent example for other judges and lay magistrates and legal advisors to actually see how the due process of law works. So either way, there's always the silver lining. If they rule in my favour and dismiss the costs, that's going to create tremendous interest in the substance of the arguments, which will help at least reduce the cost of the poorer people, because the vast majority of people are nailed with the costs which are well excessive. And at least if we can get the cost down to reasonable, and reasonable should be no more than £10 for a council tax hearing. And that then means the people that are hardest hit by these costs, we do this because we can afford it. We're trying to push it so that we get back to a fair and just society. So a lot of us aren't personally, even when they rule against us, it's not the end of our war. But if you've got limited income and you're being overcharged by £100, that's almost £10 a month. That really does affect people. It doesn't sound like a lot if you've got something, but if you haven't got something, that really makes a major difference. So that alone, and the barrister, he tried to avoid that and misdirect the court. Again, I did call him out for this, because he has an obligation not to knowingly or recklessly mislead the court. A barrister works for the court. He's an officer of the court. And so he brought in a £70 price cap because I said £10 is excessive. Their costs were £75 or £76. And so what he was trying to do, despite me reading out from the UN judgment, you cannot compare your cost to anybody else, he pulled in from Wales, where there's a cap on it of £70. And so basically what he was trying to do is say to them, hey, look, we only charge 75, it's perfectly reasonable. Despite having been told you cannot do that. And so it was very interesting, but absolutely no substance to any of the things which we've been working with many barristers now around the country doing this stuff. Really, so far, there's zero arguments to rebut what you're saying.
So overall, everything on track for you, yeah?
Oh, yeah.
Yeah. Onward and upward, 28 days?
Within 28 days, it'll be able to be made public. I'll know the answer before that, because it's a reserved judgment. But the condition of that is I obviously can't speak about it and act upon it. But basically, it's absolutely insane. The order that I avoided, one of the main reasons it was voided was because the council did not provide costs to the bench. Today, they did not even have the costs to the bench, despite knowing. That alone is a reason for the judge to dismiss the case. And this is what's happening. They just ignore everything. They think they're above the law.